Welcome to the Hardworking and Prompt Committee on Government Affairs. Will the Secretary please take the roll?
Assemblyman Carter.
Present.
Assemblyman DeLong. Assemblyman De Silva. Assemblywoman Duran. Assemblywoman Gonzalez. Assemblyman Gurr. Assemblyman Hibbets. Assemblyman Koenig. Assemblyman MacArthur. Assemblyman Wynn. Assemblywoman Taylor. Assemblywoman Thomas. Chair Torres.
Welcome to the audience here in Carson City, those joining us in Las Vegas via teleconference, and those listening over the internet. A couple housekeeping items before we get started. Please remember to silence your electronic devices. If you wish to testify, please sign in at the table by the door and provide a business card to the committee secretary. For those joining online, please be sure to mute your microphone when you're not speaking to minimize any background noise. When testifying, please turn on the microphone and clearly state your name, spell your name, and state your affiliation, if any, for the record. Then turn the microphone off each time you are done speaking. Handout should have already been provided to the committee staff. We expect courtesy and respect in our interactions during the meeting, even if we do not agree with another person's position. Committee members will use their laptops to view handouts and other documents. Please do not view this as a sign of disrespect or inattention. Public comment will be taken at the end of the meeting. Each person will be limited to 2 minutes. In addition, the public may submit written testimonies to the committee up to 24 hours after the hearing. We will be taking the bills out of order for today's so we will begin with SB 434. So at this time, I'll open the hearing on SB 434, which revises provisions related to retirement. Senator Neal, welcome back to the hardest working committee. Are you ready for this?
Yes, as long as you remove the word prompt, we're good.
You mean the hardest working committee? Senator Neal, are you ready? You may begin.
All right. Good morning, Assembly Government Affairs. I'm Senator Dina Neal here to present SB 434. You do have an amendment. So if you have an amendment, then I'd like to thank Mr. Killian for the first amendment. If you have this one, throw it away. If you have the second one that's dated 5/17, that's the one you should pay attention to, which basically removes the section and then restores the section. So with that, I will start with Section 1. So basically, Section 1 is about creating a social safety net for employees in the state of Nevada. So there's been a long-standing conversation around substitutes in the state of Nevada and how they are necessarily treated within the PERS system. Section 1 basically includes them into the membership where they can at least start earning credit by being half-time employees. So currently, under NRS 286-495, for purposes of retirement eligibility, there's a threshold of half-time or more at 720 hours for all employees. So long time ago, the board, when I say board, the school board adopted a policy under 286-200 that the threshold for any school district employee be half-time or more to be enrolled in PERS and thus must work at least 720 hours a year. However, there was a specific exclusion for substitute teachers. This particular version in Section 1 puts them in the same way as a cafeteria worker would be eligible to work 720 hours a year and get enrolled in PERS. It now will allow a substitute to be enrolled in PERS. The reason why I had this conversation, I thought about this a long time ago, but I wasn't able to bring this until this session. But COVID really brought forward that we had a group of individuals, regardless of their work or their status within the district, they had no social safety net. So when the school district closed down, well, pretty much the state closed down, I think it became evident that there were persons that had they not been able to go to work, there is no retirement on the other end that will sustain them, that they will be able to rely on. And we need to start thinking about what's the social safety net we would like to pay for now versus paying for them later on Medicaid, TANF, and other. Even though we know that there are some substitutes who are probably on Medicaid now, on TANF now, but at the end of the day, you want to make sure that the citizens in Nevada can retire, that they have something other than Social Security to actually sustain themselves and move forward with their lives. In section 2 of the bill, sub 7 is the other piece of the bill. And so this also came out of issues in my district that I've seen, and also just thinking about, we had a lot of death that happened during COVID, and we also have some I would say misinterpretation on what happens with a PERS benefit to a retiree upon death. As soon as they die, unless that beneficiary is designated, it ceases, right? So I wanted to create a voluntary option, the same way as a current retiree or a current PERS person can reduce their amount to give to a spouse. I wanted to create a residue for family members who a retiree can go in and voluntarily offer to reduce their retirement by the month, so that the retiree can have a beneficiary post-death, and the window is roughly 6 months of benefit. Why am I looking at 6 months of benefit? Because in my particular district, and probably in some of yours as well, we have communities that are poor. We also have communities where the family member, mother, father, whoever it is, may be the sole breadwinner. And so the loss of that income, the loss of that potential retirement income, that's it for the family, right? I don't know in my district what I've seen, and I testified to this on the Senate side. I see more often than not people that have signs saying, little Johnny passed away, we don't have the money for the funeral expenses. And at the end of the day, the family doesn't have anything to help pay for funeral expenses or other expenses that may be of immediate need for their family members. And so this particular subsection 7 allows a couple of things to happen. So first, they can do the alternate, they can reduce their amount per month, which then gives them a written acknowledgement where they're going to designate a person, a beneficiary, and then at the time of the retirement, retirement or death, it allows for a residue to exist for the survival, beyond the survival, for a survivor of the retiree. Then you have the alternate beneficiary should be allowed to have a designated beneficiary if they survive. And so if there is an amount where it says on line 42, if the designated beneficiary dies less than 6 months after the date of the retired employee's death, any amount which has not been paid to the designated beneficiary pursuant to this subsection must be paid to the estate. And so that was super, super important to me, because the whole idea of this entire section was to create a residue for families to be able to pick up on. The other section was a section 2.5. Basically, this gets into when you have a quadro and you have a divorce decree. So a quadro is a qualified domestic relations order. And so typically they fall into it comes into the end of a divorce decree. And this makes sure that regardless, you're going to get an explanation of what that means and how it applies to you and how it will affect your retirement as a ex-spouse or future spouse. I think it's super important. And the main reason why is because I had a constituent who didn't know that the quadro was in there, right? You're assuming that a person who gets divorced, number one, yes, are they supposed to read their paperwork? But if you've ever been through a divorce, you're pissed off, you're mad, you're emotional, you're going through all kinds of whatever. But at the end of the day, all you want is for this to be over. If it was a good divorce, maybe you did read all of it. But if it was a horrible divorce where you're basically hating each other, you probably weren't paying attention to the fact that the qualified domestic relations order is in the back, which will then affect your retirement at the end, which will then allow a payout to happen to your ex-spouse. So basically, I want an explanation so that everyone is clear, and it just mandates that individuals will know exactly what the effect is. So when you get to the point of negotiating what your divorce decree is going to be, maybe you can make sure that that quadro is not a part of it. On section, let's just go to page 7. So in page 7, this basically allows, if the court adjudicates the property rights as a result of the filing, they can go in and seek to have maybe amend the adjudication or the agreement relating to the disposition of the pension, because there are certain circumstances where an individual may need to make sure that the adjudication of the rights were properly determined. So in the space of quadros, or the land of quadros, you could have an instance where basically, I'll give this as an example. If you're 20 years as a police officer and then you get married after 10 years of working, and then you're married for 5 years, the court should not calculate the 10 years previous to marriage in terms of that number for the accrual for the retirement. They should calculate the year 10 through 15, right? But the way the law works, it's year 10 through whenever you retire. So the 20 years that you work post-divorce will be accrued into that actual number that will be determined by PERS. And so I wanted to make sure that if there was an instance where maybe they're concerned about whether or not it was properly done, they could go back and ask that question, or seek a court. They could file upon a motion. It does say it has the written agreement of the parties, and so good luck on that, but at least the option is there. Maybe there's a nice spouse out there who will let you go back into court. Section 3 is basically the piece that is where you have the amendment. So lines 22 through 26 is deleted. Lines 27 through 37 is restored. And so basically what that is that I removed the frozen benefit rule, which was in the bill when it passed out on the Senate, and then it restores it to the time rule. And so ultimately, that's what the bill does now. And it doesn't do any of the other things that I had opposition for on the other side. And so with that, I'll open myself up for questions.
Thank you, members. Any questions? Assemblyman Hibbets.
Thank you, Chair, and thank you, Senator, for bringing a PERS bill. It is one of my favorite subjects. So my question is on the beneficiary, the new option 8, which, man, I gotta get the section 1, subsection 7. Or, I'm sorry, section 2, subsection 7, where you have the new option 8. Well, I guess my question is why put this in when options 2 through 7 all give the beneficiary the reduced rate for life as opposed to 6 months?
So Senator Neal, for the record, so my understanding is that a survival benefit where you're allowing for the amount of the retiree, setting aside the amount for the retiree that they were going to earn to then be applied post-death is not something that was currently in statute. And I'll let PERS come up and correct me or state, but my goal was to create a residue after death that would still be able to be paid out to the estate or to a beneficiary post-death.
I'm assuming we can have PERS clear that up, and I'd also like to commend you on the fixing of the divorce thing.
I didn't fix it.
Well,
I mean, had the bill come in, maybe I would have, but I didn't fix it. I mean, people are still going to basically have an unfair practice where you're going to be divorced and have to pay out to an ex-spouse and you're no longer with them for 20 years that you were never even married to them. So I didn't fix it.
thank you, Senator. Thank you, Chair.
Members, any additional questions? Yes, ma'am. Assemblyman Thomas.
Good morning, and thank you, Madam Chair, and thank you, Senator, for your presentation. And I'm happy that the divorce thing didn't go, because I had a happy divorce. But in any instance, he didn't get anything, I didn't get anything. So
And
we're
that's how
good.
it should be. If you marry a broke person, you
We're
get
good.
exactly what the community interests of nothing.
My question actually has to do with subsection 7, and you say designation, and I know that you just, to our fellow assemblyman, explained that, but I do have a question. I'm not understanding if a person that, because I'm a PERS recipient, so when I went in for my PERS, I was told, here you go. Who's your designator? If you want to. They explained all of that. So a person that gets all of that information and they determine that they don't want a person to be designated as their beneficiary, they have that option. Or they can do that, while they are collecting their PERS. My question is, if the person dies, their choice was not to put a designator in there. So we're going against what that person wanted. Just a question.
So when I read this, so if you look at line 43, it says, except as other provided in subsection, if the designated beneficiary dies less than 6 months after the date of the retired employee's death, any amount which has not been paid to the designated beneficiary pursuant to the subsection must be paid to the estate of the designated beneficiary. And so I hear what you're saying, but I want to create a residue. We have family members or folks in my district who literally, this is the only income that they're relying on. This is the only income that they believe may exist. Some people believe that they're actually entitled to, even if they're not designated, entitled to get money, and it actually is not something that they can get if they're not a designated beneficiary. It's not a cash payout. And so I want to make sure that there's at least enough money within these families to allow for residue to exist to pay for expenses post-death that may not even be considered. Now, this is voluntary. A person has to pick this option 8 in order for any of these triggers to happen, which are in subsection 7. So if a person doesn't select option 8, none of these things are going to apply. So I'm not mandating an activity occur unless they pick option 8. If they pick option 8, there are several things that occur. And I think it's important to have some kind of residue for the families that will go to the estate. I have seen extreme situations where literally when we talk about wills and people planning, like you could have a retirement and not even have a will. You could have a retirement and nobody knows exactly how the funeral is supposed to be paid for. Nobody knows how the next mortgage payment is supposed to be paid for because there is a single person in the family who is the breadwinner, who has been taking care of all of the situations. And so the estate still falls into the family. And I think that that's very important to allow some kind of residue to exist.
And at this time, we'll go ahead and go to legal.
Thank you, Madam Chair, Asher Killian, Committee Counsel, and at the risk of moonlighting as a PERS employee, I'm just going to try to cover this briefly, and if I need to be corrected, I'm sure PERS will say this more eloquently than I do. So NRS 286-590 establishes alternatives to an unmodified service retirement allowance. The retired employee always has the option to choose an unmodified allowance, which is where the employee is paid for the rest of their life the full benefit that they've earned through their employment. The options in 286-590 are voluntary at the election of the retired employee, and they work by reducing the amount of money paid to the employee on an actuarial basis and the amount necessary to pay for the benefit paid to somebody else. So no retired employee would be obligated to choose a beneficiary and choose any of these options. They could still choose to receive their full retirement. And to Assemblyman Hibbett's question, a retired employee may choose this option versus the option that pays a designee for life, because less money would be required for that benefit. So the amount paid to the employee for their life would be higher because it would have to be reduced by a smaller amount for a benefit of 6 months after death versus a benefit of the entire life of the designee. I think that was accurate, and I'm getting a nod from PERS, but certainly they could clear that up if I misstated any of that.
Next, Assemblywoman, conclude your questioning? No problem. Assemblyman Carter.
Good morning. I'm trying to wrap my head. I think I've figured it out from reading through the crossed out lines and stuff in here now. So I'm talking specifically about section 3 now. That what we're trying to achieve here is that, let's say that they were married for 5 years. The ex-spouse is entitled to 5 years of PERS credits, but only at the value they were during the marriage, not at the value they are at retirement date?
So, Senator Neal, for the record, so we're asking about the crossouts. I wish I'd just kill this bill. Anyway, listen, this is how it works. I'm going to use you as an example. You were married, let's say I'm just going to use a police officer. You worked for 23 years as a police officer. Somewhere 10 years in, you decided, hey, I'm going to get married. You were married for 5 years. You get divorced. There is now a quadro in your divorce decree. You continue to work for another 20 years after divorcing your spouse. When you go and submit to PERS your retirement, they then tell you you have a quadro. And now the division problem, right, is the 20 years that you worked after you divorced them is now included. So it allows for the PERS benefit to keep accruing post-divorce and then to take from the highest amount possible, which are all the years that you worked without that person, and then do the division problem. So the ex-spouse gets the 5 years community plus the 20 years that you worked, and then there is a math problem that happens that calculates that 25 years to say that this is the benefit that they should receive. That is currently how it works. So PERS can break down the math. But basically, the current rule allows the ex-spouse to take benefit from all the years that they weren't with you, and so that the pie is larger, so that the community interest is then split from a larger amount versus what it was at year 5. What I had in the bill was the frozen benefit, which was to freeze it, meaning at year 5, whatever was accrued is what you were going to get. Meaning this relationship ended, whether or not it was year 10, whatever the community interest was there. I was using the military rule that whatever community interest was there from the 10 years of marriage, it would be divided. The argument was, well, why don't you want the person to benefit from the additional years that the spouse worked without them? And I was like, because it's absolutely unfair. If you were not together, why should you benefit from the work that I did without you? We're no longer together. So year 10, year 20, that's when I wanted it divided. That's what I had a lot of opposition over, because they were like, well, it should be allowed to accrue, and so there's a larger piece to give to the ex-spouse. And then I also had the argument, well, they're not receiving any interest. So the argument was, well, the ex-spouse is waiting for the divorce and waiting for the person to retire, and that wait has a cost. And I'm like, does it though? If you left them, this relationship is over. So whatever I earned in this relationship in 10 years, that's what you get. That's the half of the community property that you should be entitled to. You should be entitled to nothing greater than that, because I feel like it creates a first and second position. Because if you get remarried, then your first spouse, when you retire, has their hand out saying, I would like my check, please, based on the next 20 years that you work. And your second spouse is sitting, so what am I getting? So that's why I had that in the bill, but we had a lot of opposition. I carried it to this side, and now it is deleted.
You know, Senator Neal, I think it's really hard sometimes for us to know how you feel about legislation. But I think you really helped clarify that this morning. Members, any additional questions? Assemblyman Taylor. And I'll remind the committee, so we eliminated Section 3, so let's try to stay off of Section 3. If there's other questions for the Senator, thank you.
Okay, thank you, Madam Chair, and thank you, Senator. It's always a joy to start my day with the realness that comes with Senator Neal. We get Senator Neal, we get all of Senator Neal, and that's not a bad thing. I appreciate you for that. Just a quick question on the PERS for substitute teachers, if they meet the criteria, so many hours and so on. The way PERS work, as I understand, is as the employee, it reduces your pay sum as you pay into the PERS. So is there a provision with if a substitute teacher is like, you know what, I don't want to do that because I don't want my pay reduced?
So I'll let PERS answer that. I'm assuming that just the same way as we have an option in the legislature to turn down our retirement, we could do the same thing there. I'm assuming that somebody maybe they would like to keep their $27,000 a year and not have a retirement benefit. I don't think that would be wise, because if a cafeteria worker is allowed to earn credit, then why not you? I don't know how much the cafeteria workers make within the system, but I wouldn't assume that they're making a whole lot more than a substitute.
I think that's fair. I just wanted to know if they have that chance to opt out, if they choose to.
We're going to go to Mr. Killian as well.
Thank you, Madam Chair, Asher Killian, Committee Counsel. So generally, PERS is a mandatory membership system under NRS 286-293. If you work for a public employer for at least the minimum number of hours, you are required to be enrolled in PERS. And so PERS bases its actuarial assumptions around that fact that if you work for a public employer, you work at least the minimum number of hours, there is no option to opt out. Everyone has to be included, and it bases its rates and returns on the expectation that all of those positions will still be included in the system.
And Senator Neal, for the record, I think that's a good thing. It's a social safety net. You want people to have something.
Okay, I appreciate that. Thank you, legal, and thank you, Senator.
Members, any additional questions? Senator Neal, any additional statements? Looks like she is finally out of words for today. At this time, I'll invite anyone wishing to testify in support of SB 434. When you're ready, you may begin.
Kent Irvin, Nevada Faculty Alliance. I would like to testify in support, in particular, for Section 1. It doesn't affect us as faculty at higher education, but we think the principle that a person who, we do follow PERS very carefully, a substitute teacher who works long-term should, like other employees, other public employees, be able to be in the PERS system. PERS could explain this better than I, but there is a choice. If a person is only going to do it for a few years, they could choose the plan, I believe, where they don't vest for a certain number of years. Regarding Section 2, we would be neutral, but I think I maybe can provide a little context. I married into PERS. When my spouse retires in a couple of years, this would be a choice. I think it would be a choice of the full benefit versus doing this versus a life insurance policy that would provide some benefit, death benefit. For state employees, PEB currently provides $7,500 to retirees as a basic life insurance. That's going to increase to $12,500. That's just enough for a funeral. And for post-2011 hires in the state, there will be no such benefits. So this is an option. We're neutral, but I think that's kind of the context. As far as Section 3, we have no position. That's the province of family law, which is above my pay grade.
Thank you. At this time, is there anyone else here in Carson City or in Las Vegas wishing to testify in support of SB 434? I don't see anyone. BPS, is there anyone on the line wishing to testify in support of SB 434?
Callers, if you would like to testify in support of SB 434, please press star 9 now to take your place in the queue. Chair, there are no callers choosing to provide support testimony at this time.
Thank you. Is there anyone wishing to testify in opposition to SB 434? Don't see any here in Carson City. Is there anyone in Las Vegas wishing to testify in opposition to SB 434? When you're ready, you may begin.
Madam Chair, members of the committee, Marshall Willick. I am a national pension expert. With the deletion of Section 3, I'll spare you the detailed opposition, but I'll happily answer any questions anybody has as to how the time rule actually works. Otherwise, I'll confine my comments to Section 7. I want to make sure that the committee understands the impact this would have on family law generally. Retirement benefits are typically the largest marital asset. There is a rule of finality for property distributions, indicating that once 6 months goes by under the court rules, you don't relitigate who gets what pieces of property. This provision as written would eliminate that finality as to the largest marital asset and probably reopen all divorce decrees, presumably in perpetuity, to relitigation of both property distribution and conceivably alimony. It'll be great for the divorce lawyers, but it probably won't be good for many of the litigants, actually any of the litigants, who are going to be forced to return to court again and again and again if the primary marital asset is to be sought to be redistributed. It's probably not a good idea, and it probably shouldn't be there. There are reasons for the rule of finality in family law. I'll gladly answer any questions that anybody might have about how the family law system works, how our court system works, how our court rules work, or how pensions work.
Members, any questions? I don't believe there are any questions, but thank you for those clarifications. Thank you. Is there anyone else in Las Vegas wishing to testify in opposition to SB 434? When you're ready, you may begin.
Good morning, Chair and members of the Government Affairs Committee. My name is Shelley Cooley. I'm a Nevada licensed family law attorney, and I also oppose the Section 7 of, or subsection 7 of 2.5. It will increase the cost of litigation, and it will also open up the door to alimony indefinitely. Because if we have this provision in at law, then any reasonable family law attorney is going to ensure that there's also a reservation of jurisdiction for alimony. So while you may attempt to reopen and modify the property distribution that was done at divorce, you're also opening up yourself to an alimony claim 5, 10, 15 years post-divorce, because you've left this open. This is the reason that we have finality in divorce decrees. It's not modifiable, and it should remain that way. Subsection 7 should be removed or withdrawn as well. I hope that you will oppose the inclusion of that provision in this bill. Thank you.
Thank you. Is there anyone else in Las Vegas wishing to testify in opposition to SB 434? I don't believe I see anyone else in Las Vegas. If there is, please go ahead and approach the table while I go to the phones. BPS, is there anyone on the line wishing to testify in opposition to SB 434?
Callers, if you would like to testify in opposition to SB 434, please press star 9 now to take your place in the queue. Chair, there are no callers choosing to provide opposition testimony at this time.
Thank you. Is there anyone else? Is there anyone wishing to testify neutral to SB 434? When you're ready, you may begin.
Good morning, Chair, members of the committee. I'm Tina Liss. I'm the Executive Officer of the Public Employees Retirement System. The Retirement Board has voted to be neutral on Senate Bill 434. There is one thing I did discuss with Senator Neal this morning, and since there is a proposed amendment, one thing that we would like to request is an effective date of July 1st rather than passage and approval, to allow us a little bit of time to for our actuaries to run the factors that would be required to reduce the benefit for the new option 8 and also for the enrollment of substitute teachers. That's just something that we would request, that it be July 1st effective rather than passage and approval. Otherwise, the board is neutral, and I'd be happy to answer any questions that you may have on how this affects PERS.
Members, are there any questions for PERS office? I don't believe there are any questions, but I did have one question regarding that change. And did you want it for July of this year, or? I don't think your mic was on, so I apologize.
I'm sorry, I apologize. I'm Tina Liss for the record. July 1st of 2023.
And I believe Vice Chair Duran has a question.
Thank you, and I appreciate, this wouldn't go retroactive, would it, or is that up to, this is just starting July 1st and moving forward?
This button is, Tina Liss for the record. So for the July 1st, that was mainly, we were concerned mainly with the option 8 factors to calculate that. So that clearly would be a going forward, that no one would be able to select option 8 unless they retired on or after July 1st of 2023. As far as the enrollment of the substitute teacher, July 1st is a good date because of a new school year. However, I am not 100% sure on the intent of the 720 hours. So if it comes into place, say if it were to go passage and approval and it were in effect June 1st. For the retroactive question, I guess I'm going to tell you I'm not 100% sure, because if it were, and this may be a question for your legal, because for a substitute teacher to be enrolled, they would have to have made that half-time threshold, which is 720 hours. So they would have had to have worked 720 hours. The way that generally works is once the employee hits 720 hours, that's when the school district will enroll them. Is that correct? Yeah. And so when the question would be, if this were effective, say, June 1st, would they enroll anyone who has hit 720 hours on June 1st, or would it be they have to have worked 720 hours after June 1st? And I'm getting the yes from the council. So I guess I'd rather let him answer that question.
Thank you, Madam Chair. Asher Killian, Committee Counsel. So there is generally a presumption against retroactivity in legislation unless there's a specific provision calling for it to be retroactive. So if this were upon passage approval, if it's July 1st, that's between school years, so you're not going to have any teacher that qualifies during that partial year period because there won't be a partial year period. But if this were passage and approval, since there's no language indicating any retroactive effect, it would only become effective for teachers who work during the 22-23 school year if they could satisfy the 720 hours requirement between the effective date of this bill and the end of that school year. And since the effective date on passage and approval would be sometime in June, I think it's probably a literal impossibility that they could actually work 720 hours between the effective date and the end of the school year.
Thank you. Thank you for your testimony today. Members, any additional questions? I don't believe there are any. Thank you. Is there anyone wishing to testify neutral to SB 434 in Las Vegas? I don't believe I see any BPS. Is there anyone on the line wishing to testify neutral to SB 434?
Callers, if you would like to testify neutral for SB 434, please press star 9 now to take your place in the queue. Chair, there are no callers choosing to provide neutral testimony at this time.
Thank you. I invite the bill sponsor for any closing remarks.
Thank you, Assembly Committee on Government Affairs, for hearing this bill. So on page 7, sub 7, where the conversation from the opposition, and I'll have if the chair would like Killian to address this, but I went round and round on res judicata, right? It's a policy choice in order to have this language in here. It didn't violate res judicata. I literally debated legal staff on the other side of the house trying to figure out how I can get something in there if there was an issue that needed to be re-looked at. And so and this was the policy choice that was made after reviewing the law and whether or not I was tampering at all with what is known to be res judicata in law. And so if Mr. Killian would like to add, at the end of the day, I think the bill, I attempted to remove the opposition. I'm trying to open the door for folks that at least want to have a conversation about whether or not there was a proper adjudication. And I think that would be the cost that a citizen would like to take on for themselves. If you want to go and open this up and spend your money, then you go spend your money. Not everyone is going to choose to do this option, but there may be some people who feel that they want to make sure that the calculation was right and that it was proper. And so I don't think that, the cost of litigation is something that bears a burden on the state because it's the citizen who's going to pay it. It's the citizen who's going to write that check to the attorney and say, I would like to travel this road. And I don't know why we would care whether or not they choose to spend thousands of dollars on what they want to do or not. I think facts are people don't really understand how the Quadro works. They don't. And so whether or not, you have a good attorney, you could have a bad attorney, but not everybody understands exactly how it affects them and how it affects their divorce. And some people, it's just a surprise. Call it what you want, but at the end of the day, I'm just trying to open the door to allow folks to at least have a conversation about it. And a court could deny it. So I don't understand why we would even debate that issue because a court could be like, I'm not going to accept this motion and actually we're not going to reopen this. But at least the option is there for them to have that conversation. And I want to thank Assemblywoman Torres for allowing this bill to be heard, for allowing me to harass you until it was heard, and I probably should have just killed it anyway. But have a good morning, everybody.
Senator Neal, you never harass me, but you do send me an obnoxious amount of messages asking when the bill is going to be heard. So thank you for your persistence. We appreciate it. At this time, we can go ahead and close the hearing on SB 434, unless we want to invite Senator Neal back up for more questions. Senator Neal is quickly fleeing the room. She does not have any more time for this bill. And at this time, we'll go ahead and open up the hearing on SB 371, which revises provisions regarding local governments. As just a note to the committee members, I do expect that, I have a number of people that have signed into this to speak on this piece of legislation. So we will have a presentation from Senator Flores, who I'm sure will give us a hefty amount of hypotheticals this morning. And so that presentation will be no more than 15 minutes. After that presentation, we'll have our questioning. After a line of questioning, we'll go into support. I will invite 20 minutes of support. After that, we will be followed by a pretty brief presentation, is my understanding from the opposition. It should probably be about 5 minutes. If we have questions, I'm sure we will be able to ask them at that time, followed by 20 minutes of opposition testimony. Then we will go into neutral. I do not expect neutral to need time for any presentation, but we will have time for that if necessary. So at this time, I'll invite Senator Flores to please begin when you're ready.
All right. Good morning, Madam Chair, Vice Chair, esteemed colleagues of the Government Affairs Committee. It is great to be home once again. I am Senator Edgar Flores here proudly to present Senate Bill 371 on behalf of my constituents and other Nevadans, but particularly my constituents in Senate District 2. Madam Chair, because at your request, I'd like to open up with a couple hypotheticals that I think would put into perspective what we are doing today. And I say that sarcastically, as I know you appreciate that more than anyone else. But I would like to just provide some context. And before I get into the bill, I'd like to walk us a little bit through the history before we get into Senate Bill 371. In 2015, we had Senate Bill 29 and Assembly Bill 493. And it's important that we start the conversation there because I want to make it abundantly clear that at that time we were having a conversation about Dillon's rule versus home rule, and ultimately we came up with something called modified Dillon's rule, and some folk would argue about that. But that's the terminology I'm going to be using. There are two schools of thought, very plainly put, on whether or not we believe as a legislature that we should be the gatekeeper or that we should be sending things down to the local jurisdictions to handle there. And there's been a constant debate for many, many years in this body about that. In 2015, through Senate Bill 29 and Assembly Bill 493, those of us who argued that the legislature should always be the gatekeeper and that local bodies should come here and ask for permission every single time lost. I voted against both of those bills because I didn't want to give so much power to the local government. I wanted them to come here every single time and ask for permission on a whole variety of things because I thought that this would allow everybody, the entire state, to participate in the conversation, not just the folk impacted. However, there are a whole host of things that are specifically grounded in very specific jurisdictions only. And that is the focus of the conversation today. In 2015, I believe, and not only do I believe, but our legal here in the legislature has made abundantly clear that matters of local concern involve affordable housing, that local jurisdictions can, in fact, engage in that. I put legal on record in the Senate, and I asked them to please provide feedback on whether or not we even believe this bill is necessary. The answer was no. I want to take you back to 2019. Senator Ratty presented a bill, and I, as the chair of this committee, also said we don't need this conversation. Local jurisdictions can already did it, and I myself got in the way of that legislation moving forward. It is now 2023. Okay, and this first went into place in 2015. We've been having this ongoing debate for 8 years, and I think it's time for us to finally settle it. I believe our legal is incredibly brilliant. I think they are the best amongst the country and most definitely in the state, and they've made it abundantly clear that we can do this, but unfortunately, there's still some debate at the local jurisdictions, and there's been resistance. So based on that, I set off to address it with this bill, not to increase, not to grant any further powers than what was already granted in 2015. I am simply saying that in matters of local concern, particularly affordable housing, we should allow local jurisdictions to decide whether or not they want to engage or not. And the reason for that is there is not a one-size-fits-all, unfortunately. There isn't. Right now, we could say we're going to implement provisionary zoning. And in some areas of Nevada, some people would say, great, that's a great idea. And other areas of Nevada said, what are you talking about? That would never work here. We could say we're going to implement statewide rent control. Some people would say, why would you do that here? That doesn't make sense. The needs of Nye County are very different from the needs of Clark County. The needs of Washoe County are very different from those in other jurisdictions, particularly if we look at our rurals versus Clark. The needs are just different. We have to, when it comes to affordable housing, allow for the local jurisdictions to address the needs of those jurisdictions in whatever best way fits them. And Madam Chair, I just want to provide some just basic data that I think is really important and why we're engaging in this conversation presently. Presently, it's estimated that 6,900 people are experiencing homelessness on any given day. That's about 22.4 out of every 10,000 people here in the state of Nevada. Presently, it's estimated that over 243,000 renter households in Nevada are paying over 30% of their household income on rent. The reason that's relevant is because affordable housing is defined by the U.S. Department of Housing and Urban Development as housing for which the occupants are paying not more than 30% of household income for gross housing cost. And the reality is that there's just not enough. There's just not enough low housing housing units in the state of Nevada to address our needs. We are in a desperate, dire situation. I think a lot of us in this room have the luxury of going home to a home, and I think that is a beautiful thing, but I think we are in an ecosystem that deprives us of what's actually happening in the state of Nevada, that we have a lot of human beings that are desperate for us to take action. And part of taking action is us providing the tools and clarifying that the tools that already exist with local jurisdictions to do whatever is best for them. And just preemptively, Madam Chair, all I am doing here, again with this bill, is clarifying the authority that local jurisdictions already have. Second, preemptively, I know the opposition will come in and will suggest that things like inclusionary zoning, payments of money in lieu of performance of an obligation, linkage fees, et cetera, that's all part of affordable housing. They're going to suggest that that's very complicated and difficult, and how are you going to implement that? Simply, it's going to be implemented the way everything else is implemented by local jurisdictions. There's going to be a whole host of hearings. There's going to be working groups. There's going to be a lot of conversations happening at the community level, and they will decide whether or not they do it. And by the way, local jurisdictions doing nothing is them implementing this bill, because this bill makes you do absolutely nothing. It is only clarifying the authority you have, something that was given to you in 2015 through the modified Dillon rule that we implemented. And with that, Madam Chair, I'm open for any questions.
Thank you. Members, any questions? I'm going to go ahead and start off with Assemblyman De Silva.
Thank you, Madam Chair, and thank you, Senator Flores, for bringing this bill here. I just had a very quick question. Maybe even legal can also delve in onto this. So again, this is something that came up, has come up many times in community conversations, town halls. This issue about the local government versus the state authority to let the localities enact affordable housing policy. So my and this is maybe a freshman question. So can you go back into the actual history as to what was the actual issue that the local government was saying in regards to their inability to enact any sort of local policies? Because I know that it was a legal question, but if you could just define that so we can get a historical perspective as the legislation was playing out from 2015 to today.
Thank you for that question, Assemblyman De Silva. Senator Edgar Flores, for the record. What I'll do is I'll direct your attention to NRS 268. And there is a declaration and a finding there that walks you a little bit through what Dillon's rule is and what we are hoping to accomplish. But more importantly, they define matter of local concern under NRS 268.003. And it reads, matters of local concern means any matter that primarily affects or impacts areas located in the incorporated city or person who resides, works, visit, or otherwise present in areas located in the city and does not have a significant effect on impact on areas located in other cities or counties. B, it is not within the exclusive jurisdiction of another government entity. And C, does not concern a state interest that requires statewide uniformity of regulation, the regulation of business activity that are subject to substantial regulation by a federal or state agency, or any other federal or state interest that is committed by the Constitution, statutes, or regulations of the United States, or in this state or federal state regulation that preempts local regulations. And there's a few other things that go in there. I make that point because if we talk about what it does not concern, and I'm looking at NRS 268.003, sub C sub 1, sub C sub 1, that says it does not concern a state interest that requires statewide uniformity or regulation. I often go back to that because that's where I engage in this particular conversation. statewide uniformity when we talk about affordable housing cannot exist. If any one of us came up with a beautiful, perfect solution to any one of our local jurisdictions, if anyone did that, I guarantee you everybody else would start arguing with you because they would say that makes sense in your district, but it doesn't make sense in this district. And that's why I am pushing this, because we've already made that decision. I originally did not agree with it. And the local jurisdictions in the 2015 legislation, they came up and they very enthusiastically talked about how frustrating it is for them to have to consistently come up and ask for permission on everything. And they felt that everything needed to be legislated to them on matters that they didn't believe needed to take up this much attention and or effort from this legislative body. And there was a lot of folk in this building at the time that agreed with that. That's why it passed. But that was the issue, right? The local question that was posed then that ultimately won was, do you want us to come up here every single time? Or are there certain matters of local concern that we can agree this only really applies here? We should be able to have the authority to take care of that ourselves without having to come up and ask all of you for permission every single time. And that's how we got to where we are now. There's going to be a whole host of debate, and one of the things that people will try to suggest is, well, what about imposing taxes, et cetera, et cetera? We're not expanding the scope of what was already agreed to in 2015. I'm making that abundantly clear. We are just simply clarifying what our legal has, since 2015, been very consistent on, and that they in fact can engage in that. And I don't know if you want to defer to Mr. Killian to add any additional remarks through his perspective, through our legal perspective, better said.
You must have read our bind, because the hardest working committee was already on that, and our hardest working legal counsel in the building, Asher Killian.
Thank you, Madam Chair, Asher Killian, Committee Counsel. So just to provide a brief overview of this area of law, there are two general approaches to the powers of local governments in United States legal history. One is Dillon's rule, the other is home rule. And they're basically flip sides of the same coin. Under home rule, the idea is that local governments can do anything unless the state government says that they can't. Dillon's rule, which is what the Supreme Court decided long ago Nevada follows, is the opposite of that, that local governments can only do the things that the state has said they can do. So if the state hasn't given a local government a power, it does not have the power to do that, and it must ask permission from the state government. In 2015, the legislature enacted bills that added provisions for both cities and counties. For counties, it's in NRS 244-137 through 146. For cities, it's in NRS 268-001 through 268-0035 that modify Dillon's rule. So rather than local governments cannot do anything unless the state government says that they can, the state government has said local governments can do things relating to matters of local concern without permission from the state. That's the state giving blanket approval for local governments to do things relating to matters of local concern. The senator mentioned the definition of matter of local concern. Those definition sections also give an illustrative but not exhaustive list of things that are matters of local concern, which includes, without limitation, planning, zoning, development, and redevelopment in local governments. Additionally, in NRS 244-146 and the corresponding section in Chapter 268, the legislature explicitly provided that local governments have all other powers necessary or proper to address matters of local concern for the effective operation of local government, whether or not powers are expressly granted. And if there is any fair or reasonable doubt concerning whether a power exists, it must be addressed in favor of the local government exercising its power to address that matter of local concern. So it's been our office's position since the legislature adopted these laws back in 2015 that because planning, zoning, development, and redevelopment in a county are matters of local concern, because those matters do not require statewide uniformity of legislation, and because those matters are not committed to regulation by any state or federal body, and because the law explicitly provides that if there is any doubt, it has to be resolved in favor of the power of the local government to act, that affordable housing is a matter related to planning, zoning, development, and redevelopment. So by the passage of this law in 2015, the legislature has granted the local governments the power to address issues relating to affordable housing. And to the extent that there's any doubt about whether that power exists, because that doubt has to be resolved in favor of the power of the local government to act, that even if this were challenged, because there has been no express legislative intent that local governments cannot perform these duties, any question would have to be resolved in favor of the power of local governments to act. Thank you, Madam Chair.
Thank you, Senator Flores and Council Killian. That's an excellent dissertation over there. It offers great clarity. Thank you. Thank you.
Our counsel, Mr. Killian, is definitely known for very brief statements and keeping it very unclear. Members, any additional questions? I have Assemblywoman Thomas, and then I'll go to Assemblyman DeLong. I guess Mr. Killian was just answering multiple questions in his response. Thank you. Assemblyman DeLong.
Thank you, Chair. I don't think council will need to respond to this one. This may be another freshman question, but I'm not sure what happens in Clark County, but where I live in Washoe County and the city of Reno, we've got affordable housing that's going on. So from that perspective, I don't see why this bill is necessary, except for the fact we've specifically called out rent control. And to me, that's the issue in this bill, is rent control. And I think what we need to be considering is what's the policy of the state as it relates to rent control. The history of rent control is depreciating assets, reduced quality of housing because there's no maintenance done because the economics don't work. So my perspective is that rent control doesn't work. We should not be supporting it.
Thank you, Assemblyman DeLong, for that comment. Senator Edgar Flores, for the record. And I appreciate that, and I don't know that everybody agrees with you that your local jurisdiction is engaging in all forms of affordable housing conversations and has not said that at times they cannot engage in certain things. But even if that were true, I think you're hitting my point and you're making it for me, and I really appreciate you being aligned with me on this, because you're agreeing with me that there's some local jurisdictions saying, yes, we have this authority. I don't need this bill. And yet we're having other jurisdictions saying the complete opposite. We can do something, some we cannot do something. The reason I specifically listed rent control, and we can do anything, we can add 40 other things that fall under, if you wanted to, in this bill, that fall under this conversation, is because specifically wanted to make it abundantly clear that if there is any question, because we've had them already, there are conversations ongoing and that have occurred in the past year and a half, 2 years, 3 years, depending on the jurisdiction we're talking about, where they've brought up conversations about, for example, rent control. But not just that, a whole host of other things. The conversation has been that we can't do it. So we are just simply making it abundantly clear. Again, if you wanted to add a list of 40 other things on there, I would amend the bill to add a whole host of other things that can be done under affordable housing, just to make it abundantly clear that those all fall under that. But that's the only reason we called it out in that way.
A quick follow-up. I actually don't have anything I want to add to this bill. And from my perspective, I don't think we need this bill. But from a policy perspective at the state level, I do not think we should be endorsing rent control.
Madam Chair, if I could just make clear, Senator Edgar Flores, for the record, again, the bill as written, and we have our phenomenal legal counsel that can verify, confirm, and provide a dissertation on this. We are not forcing anybody to do anything. We are simply saying you can, if you want to. And if the state decides to do absolutely nothing, you're actually doing what the bill allows you to do, which is do nothing if that's what you choose to do. Or you can engage in this conversation. And in no way are we endorsing anything as a state. We are just making it abundantly clear that local jurisdictions can do it. That is all we are saying, should you want to do it. And it will take a very long time. Going back to our Assemblyman's remarks, you could passionately advocate against rent control should that try to be implemented by a local jurisdiction in Northern Nevada, and provide all the arguments you so eloquently pointed out that you believe why it's bad, and bring all the data you would want to. The community could do the same thing. Everybody would be able to participate. You'd go through incredibly long, complex hearings that would go probably late into the hours of the night. And eventually you might decide not to do it. But we are just clarifying that you have the authority to engage in that conversation, period.
Thank you. And we're gonna go ahead and go to Mr. Killian.
Thank you, Madam Chair, Asher Killian, Committee Counsel. I will try to keep it as brief as possible. It is correct that all this bill is doing is making it explicit that this issues relating to affordable housing, including rent control, are among the powers of a local government to address matters of local concern. It does not create an obligation for any local government to exercise any particular power. It just makes it clear that it is within the powers that they have in their toolbox. To address the question about rent control as a matter of state policy, under the modification of Dillon's rule in NRS currently, the legislature does have the power to declare certain policies, certain items as being matters of a state concern that local governments cannot act upon. So if it were the legislature's desire, it could expressly grant to local governments the power to address issues relating to affordable housing, which we believe is already included in the powers they have to address matters of local concern, but reserve from local governments the power to enact policies relating to rent control. That's within the legislature's ambit. We believe that the existing law currently in effect would grant local governments the power to use any of these tools, including rent control. So if the legislature wished to restrict rent control, it would require legislation to take that power away from a local government.
Thank you, Assemblyman Nguyen.
Thank you, Madam Chair, and thank you, Senator, for bringing this here. I just wanted to kind of ask a different perspective. I know we discussed a lot of things about state and local the last 20 minutes, but I think my other thinking on this particular bill is that you also gave kind of the same jurisdiction for kind of conflicting entities, in my opinion. You could give me that clarification. I'm thinking county and city. Like, for example, I'm in Clark County, and there are different cities within Clark County jurisdiction. You know, if the intent is to give all of them this ability, right? I would think that Clark County should be the only one that can, because then if you give it to Clark County, and then, for example, City of Henderson may not do the same things or do things in a different way that conflicts with what Clark wants to do, then you have a whole bunch of cities in conflicting with the county. So would it be better to just give it to county and not cities, or vice versa? Because I would think that if you give both similar powers, that they could kind of go against each other in a way. Vegas could not agree. Boulder City might do completely different, and then so now we have like a bit of a chaos in this nice thing that we're trying to do and give them the empowerment to do good things, but maybe just stop at county level, because county have larger jurisdiction. And so just kind of want to hear your thoughts on that. Thank you, Senator.
Sure. Thank you, Assemblyman Nguyen, for that comment and question. Senator Edgar Flores, for the record. The hypothetical you posed, that they can be in conflict. Well, let me start off with one thing first. Again, it is my position that we're not giving them any additional power with this bill. I don't think we're giving them authority right now. It's my position that this bill is only clarifying the authority they now have. I wanted to start with that remark. To your second point on whether or not there could be conflict between city and county, that is a reality that exists today with every single thing they enact. Every single ordinance, every single passage of anything. That is a reality that exists today. In other words, presently, the city council is making decisions right now that may impact and or be in conflict with something that the county is trying to do. Presently, there are things that the county is trying to do in any county, any city, that may be in conflict, and there may require them working together. There may be a whole host of things that are happening. But we decided to do that and provide for those potential conflicts or those potential difficult conversations to occur in 2015. We've already done that. Obviously, there's a whole host of, and our wonderful council will be able to address how those issues are addressed now. In other words, when there is a conflict between a county and a city, obviously whenever we enact something, that takes precedent. We understand this, right? We enact it, and then based on how the modified Dillon rule works now, we would be dictating how that's going to work moving forward. But absent that, where we are silent, and where we are silent, and there's conflicts now between the city and county. And by the way, that is why often, and there's a whole host of pieces of legislation where we come before this body and we try to enact something statewide, because businesses, for example, were having a nightmare of a time figuring out, if I have my business that has a pole at this height, it's good for the city, but then it's wrong for the county, but it's wrong for this, and it's perfect for that, and it's frustrating for them, right? But that's a reality that happens every single day presently, and that's why sometimes we realize we do have to implement things at the statewide level, and we've tried doing that. Unfortunately, with this particular subject matter, I assure you that the perfect solution to affordable housing in every individual district would be in conflict with every other district, and we've just realized that we couldn't do it. And since 2015, we haven't done anything, and because of this constant pushback back and forth. In 2019, we once again engaged in this conversation. Again, weren't able to reach that solution, so I figured that we needed to do this. But Mr. Council Killian can provide some much more wonderful insight.
And thank
as
you,
well.
Senator Flores, for your brief remarks. Council Killian.
Thank you, Madam Chair, Asher Killian, Committee Council. I will endeavor to keep my remarks even more brief. So in general, and this isn't necessarily true in all situations, in all cases, but in general, counties are responsible for managing the land within the county outside of incorporated cities, and cities are responsible for managing the land inside of their incorporated limits. So there wouldn't necessarily be a conflict between counties and cities in the implementation of affordable housing measures as a matter of local concern, because counties wouldn't be directly managing the land inside of incorporated cities. They would be managing the land that is not in a city, and the cities would be managing the land within the city. That said, there are powers in existing law for cities and counties to enter into interlocal agreements to address issues that overlap the two different kinds of jurisdictions, and nothing in this bill would affect the power of local governments to cooperate in that way.
Thank you. Assemblyman Nguyen, did that answer your question?
Yes, that. Thank you, Madam Chair.
Thank you. Assemblyman Gur.
Thank you, Madam Chair. I will attempt to make this really short. Ditto on what DeLong said, Assemblyman DeLong. The bill's enabling, and I get that, and I understand the direction you're going, but putting rent control in there calls it out, opens up the door, puts the camel's nose under the tent for a whole lot of unintended consequences and elections that will have consequences down the road. So I'm 100% against the bill. If you take out rent control, I'm fine with it. Affordable housing is one of those things that's just aspirational, and let's go do it. But rent control is a physical act that can happen. Thank you, Madam Chair.
Thank you. Members, any additional questions? And I do have a question, Senator. So one of the concerns that I've had, and I've read through the bill a couple times, is like there's no protections that local governments will not, I'm concerned about some of the unintended consequences of local governments, and I understand your argument that local governments can do this, but I would like to see protections to prevent local governments from enacting things that would, I have fears that you might have a more affluent neighborhood and an area that is more low income, and you put the rent control in one area and not in another. And we see that in other ways that local governments have interacted with our communities, where there is investment in one side of town and not in another side of town. And so in this side of town, we'll put the rent control, or in a very urban area like the city of Las Vegas. I mean, I live across the street from the city of North Las Vegas. And so you might have rent control in one area and not in the other. And unintentionally, I do have a concern, and I don't know how that could be addressed, that you might have an area that is disproportionately low income, disproportionately, and often with that is going to come disproportionately Black and brown.
Thank you for that, Madam Chair. Senator Edgar Flores, for the record. I agree that a local city or county could potentially take action that we disagree with. In fact, that probably happens all the time, that we as a legislature looking in may say we disagree with that action that was taken, but there's recourse and procedure in place already. In other words, there's going to be open hearings. There's going to be public involvement. There's going to be working groups. There's going to be, all the folk that lobby us here will equally be lobbying in these local jurisdictions. It would become impossible for us to dictate through legislation, if you're going to implement rent control, here's the 40,000 different things that we're going to implement to protect you. If you're going to implement in lieu of fee, XYZ, here's how you're going to do it. If you're going to implement this and that, here's, it would be impossible. The whole point of this is for them to engage in that very complex conversation, because even right now, even rent control itself, not everybody would agree what that means. For some folk, it could mean that you could increase it 3% every year and that's it. For other folk, it might mean that you freeze it. For other folk, it means that there's certain protections that are triggered if it's a family member versus somebody, a complete stranger moving in. For some people, would say it only applies to houses, residential housing. For other people, would say you can't do it for apartments. There's a whole host of very complex conversations that have to take place. I am not suggesting it is easy, and I am even more adamant that it's the opposite. It is incredibly complex. That if anybody engages in the conversation of affordable housing, it will be a very difficult undertaking. What I am saying is allow for that conversation and that undertaking and everything you just mentioned, the parameters that you have to put in place, the protections that we want to make sure, the unintended consequences. That entire conversation is going to happen before the county commission or the city council, not with us.
Thank you, and I appreciate that. I guess as chair of this committee, and I've had the opportunity to work with some of our local governments very closely, it's putting a lot of faith in our local governments. And I think as my colleague and counterpart in the Senate, I guess you could probably understand maybe my unease. Thank you. I don't know if you have any response to that, but I believe that's all our questions from committee members at this time. So at this time, I'll go ahead and
Madam Chair, I would just say that some of the local council and commissioners would say the same exact thing about us. Thank you, Madam Chair. Senator Edgar Flores for the record.
Thank you, Senator. At this time, I'll invite anyone wishing to testify in support of SB 371. As a note to the public, as a reminder, we will allow 20 minutes in support. I will go ahead and go from Carson City. We'll start here in Carson City. I'll take a table full of people in Carson City, then I'll go to Las Vegas, and then I'll go to the phones and then back again. If you do have remarks, if somebody says the remarks that you already need to say, please feel free to just state and spell your name and then say ditto, so that we can get as many people to participate in this process as possible. I know there's a number of people signed in, and I am sure that there are a number of people that are on the phones as well. So we'll begin here in Carson City. Thank you.
Good morning, Chair Torres and members of the committee. My name is Paul Cath, and I represent the Culinary Workers Union Local 226. The Culinary Union has been actively engaged in the conversation around affordable housing for years, but as a result of drastic rent increases following the COVID-19 pandemic, more must be done urgently. The Culinary Union is a member of the Nevada Housing Justice Alliance, and we thank Senator Flores for bringing forward this bill. As confirmed in the Senate hearing and today, the Legislative Council Bureau believes that local governments have the ability to regulate housing policies. Our legal counsel at the union concurs, but unfortunately it seems no attorney for a local government in Nevada publicly agrees. It's incredibly frustrating for Nevadans to be in the midst of one of the worst housing crises in the nation and to have various levels of government not only unclear on who exactly has the ability to reduce that burden, but actively contradicting each other about who has that authority. Given the fast-moving and ongoing nature of Nevada's housing crisis and the biennial nature of Nevada's legislature, local governments must have a role in solving the crisis in order to ensure that Nevadans have the access to solutions that they deserve in a timely manner. SB 371 would ensure that they do. The Culinary Union urges the Nevada Legislature to support and pass SB 371. Thank you.
Mark Ellis, President, Communication Workers of America, Local 9413. We fully support this bill.
Thank you, Chair and members of the committee. For the record, my name is Susie Martinez, and I am the Executive Secretary Treasurer of the Nevada State AFL-CIO. And on behalf of over 150,000 members and 120 unions, we are in full support of this bill. Being the Executive Secretary Treasurer of the AFL-CIO, we run a statewide campaign on elections. And one of the things that I would constantly hear when our canvassers would come back was about affordable housing. And I mean, I believe that this is a bill that will help all of your constituents. That's what we are here for, to help our constituents. Thank you.
Thank you. At this time, is there anyone in Las Vegas wishing to testify in support of SB 371? I don't see anybody in Las Vegas. BPS, is there anyone on the line wishing to testify in support of SB 371?
Callers, if you would like to testify in support of SB 371, please press star 9 now to take your place in the queue. One moment, Chair.
Good morning, Chairwoman Torres and the members of the committee. For the record, my name is Robert Sumlin, Robert Sumlin, and I'm with the International Association of Machinists and Aerospace Workers, Local Lodge SC 711 in Las Vegas, Nevada. I'm here in full support of Senate Bill 371, and I urge the committee to support it as well. Thank you.
Thank you. Next caller.
Hello.
Yes, please begin.
Hello. My name is Yesenia Moya, Yesenia Moya. I am here in support of AB 371. As somebody who's currently going through a no-cause eviction because because my landlord wants to up the rent and I'm only paying a small amount. Now I'm going to be forced to fight an eviction, have an eviction on my record because somebody wants to up my rent. I am here in full support of this bill. I do believe that our people deserve some relief because now as I'm going to be forced to move out, I have to pay at least $500 or find out where I'm going to find $500 additional to pay for a smaller apartment. So as somebody who's here from the community currently fighting things like this, I appreciate that this bill was brought forward. So please pass this bill.
Thank you. Next caller.
Greetings, Chair, Vice Chair, and members of the committee. My name is Shelley Speck. That's SHELLY-SPECK. I live in Gardnerville, Nevada, and I am providing testimony today on behalf of the Children's Advocacy Alliance and the Nevada Strong Start Coalition in support of SB 371. It is time to let local jurisdictions have a say in whether they enact ordinances in their own areas. There are circumstances when the state does not need to delegate to local municipalities or provide oversight to address matters of local concern. SB 371 can help address housing stability needs in locales that might have different priorities than other areas within our state. Please consider these factors and provide your support today for SB 371. Thank you for your time and attention.
Thank you. At this time, we'll go ahead and come back to Carson City, and then we'll go back to the phones after. So come back in Carson City.
Good morning, Chair and members of the committee. For the record, my name is Christine Saunders, and I'm the Policy Director with the Progressive Leadership Alliance in Nevada, here in support of Senate Bill 371. A plan we work daily with tenants and community members across the state and hear time and time again that our community is facing an urgent housing crisis that is deeply impacting their lives. Unfortunately, in Nevada, there's been confusion between local governments and the state legislature on powers regarding housing. Therefore, even if local governments want to take action to protect tenants, they feel limited under Dillon's rule. And instead, Nevadans have been left with inaction at all levels of government for a number of years. By expressly granting local governments the ability to enact policies for affordable housing, we would allow for each region in the state of Nevada to choose the best policies for their communities and address their specific concerns and needs. We urge your support. Thank you.
Thank you, Chair and members of the committee. My name is Cody Hoskins, Political Director for SEIU 1107, and we are here in support of SB 371. According to a 2019 to 2022 study by property management tech company Stessa, it showed that in Las Vegas, rent grew by almost 25%, the second highest in the country by large metro areas, and rent grew at 36%, the highest in Reno for mid-sized metro areas. SEIU believes that affordable, attainable housing is crucial for members and our community and members of our community. SB 371 would clarify for local governments the ability to take action deemed necessary to ensure affordable housing throughout our state. We urge your support. Thanks.
Good morning, Madam Chair and members of the committee. My name is Sarah Adler, today with the Nevada Organization of the National Alliance on Mental Illness, or NAMI. And we are in support of SB 371 because it clarifies and it empowers, even if the empowerment is just to local city attorneys. We are hopeful at NAMI that by the end of this session, this body will have taken forward-looking action to enable the development of supportive housing in our state. And supportive housing is a positive alternative to incarceration for people who are mentally ill and suffering from addiction. We want the way to be clear for local governments to enable the development of supportive housing. I have had discussions with elected officials in the city of Las Vegas and in Clark County about their desire to do so. So we think this is important. One other note, affordable housing includes home ownership. And if you ever have seen the heartbreaking book, The Color of Law by Richard Rothstein, you know that we need to take action in this area, and let's let our local governments go forward and do so. Thank you very much.
Good afternoon, Chair and members of the committee.
I apologize. We're going to actually go to the, I need to go to Las Vegas and then the phone. I apologize. I have to follow the procedure. So is there anyone wishing to testify in support for SB 371 in Las Vegas? I don't believe I see anyone. BPS, is there anyone in line wishing to testify in support of SB 371?
Callers, if you would like to testify in support of SB 371, please press star 9 now to take your place in the queue. One moment, Chair.
Good morning, Chair and members of the committee. My name is Maria Teresa Lieberman Barraga, MARIA-TERESALIEBERMANN-PARRAGA, and I am the Deputy Director of Battleborn Progress. We are here in strong support of SB 371 and thank Senator Flores for bringing this forward, because by being a Dillon's Rule state, as you've heard, Nevada has had significant disagreements between local elected officials and other members of the state over whether local governments have the ability to regulate rent prices and other housing policies. While that is happening, our communities are waiting for relief as testimony. This bill will clarify what local governments can do if they wish, and then in fact have control over neighborhood stability for our communities that are experiencing high rent prices that can continue to increase. Please support SB 371 so we can bring people in Nevada some relief. Thank you.
Thank you. Next caller.
Good morning, Chairman Flores, members of the committee. For the record, my name is Russ James. I'm with the Nevada AFL-CIO, longtime member of the Painters and Allied Trades. I'm in full support of Senate Bill 371, and I urge the committee to support it as well. Thank you.
Thank you. We'll take one more caller before coming back here to Carson City.
Good morning, Chair and committee members. My name is Victoria Ruiz, and I strongly urge you to support Senate Bill 371 and its potential impact on the housing stability of Nevadans across the state. Housing stability is an essential component of individual and family well-being. It directly influences factors such as education, employment, and overall quality of life. Unfortunately, Nevada has been facing significant challenge in providing affordable housing options for its residents. The lack of affordable housing has put a strain on many families, leading to housing insecurity, displacement, and a rise in homelessness. Allowing local governments to establish rent control policies, for instance, can play a crucial role in mitigating the adverse effects of skyrocketing housing costs. Rent control provides stability and predictability for tenants, preventing arbitrary and unreasonable rent increases that often force individuals and families out of their homes. By implementing responsible rent control measures, we can strike a balance between protecting the rights of tenants and ensuring the continued viability of the rental market. Furthermore, SB 371 recognizes that housing stability is not a one-size-fits-all issue. It acknowledges that local governments and communities have a deeper understanding of their unique housing challenges, allowing them to tailor solutions that meet the specific needs of their communities. By providing greater autonomy to local authorities, we can foster an environment where innovative approaches can flourish, leading to a more resilient and inclusive housing market. So I urge you to consider the profound impact that SB 371 can have on the lives of Nevadans across all areas of the state. Thank you.
All right, I believe that was the third caller. And just as a reminder to note for the public, I am Chair Torres, The bill was presented by Senator Flores. We'll go back here in Carson City.
Hello, my name is Erica Minaberry. That's ErikaMinaberry for the record. And I am here in support of 371 on behalf of my 3 children. Because in 2018, I had to relinquish custody of my kids for 18 months because I could not afford housing while I finished my degree in social work. While I fought my way up and out of that, I was able to get my children back. However, since I got them back in 2019, I've had to move every year due to the rising housing costs in Washoe County. As it stands now, I am paying $2,050 a month for rent, and my lease is up next month. As a single mother with 3 kids working multiple jobs without any assistance, if my landlord decides to raise my rent, I will not have a place to stay. My kids will not, they will have to change schools again for the 3rd time, but more importantly, I will not know where I will go. My kids and I are terrified to be separated again. In 2021, during one of the hearings for a housing bill, one landlord said that they felt that landlords were, quote, being left out in the cold. In the testimony for opposition for this bill, you are certain to hear similar sentiments, but while the realtors and landlords are victimizing themselves for how hard it is to be a landlord, please remember that in Northern Nevada, we are literally being left out in the cold. In fact, we are freezing to death. This is an issue that might not happen in Vegas, but is unique to Northern Nevada alone. And when we ask our local government bodies for some reprieve, they blame this state body for the reason why they can't help us. So on behalf of the people freezing to death in Washoe County, please give our local governments the clear directive that they are able to help us. Thank you very much. Bye.
Thank you for your testimony. Is there anyone else here in Carson City wishing to testify in support of SB 371? I will note that ACLU was present in support of SB 371, but had to go for another hearing. Is there anyone in Las Vegas wishing to testify in support of SB 371? I do not see any BPS. Is there anyone online wishing to testify in support of SB 371?
Callers, if you would like to testify in support of SB 371, please press star 9 now to take your place in the queue.
Oh, hello. Good morning. Thank you so much, Chairman Torres and members of the committee. For the record, my name is Sean Navarro. I'm calling in strong support of SB 371. I think not only the housing, probably the most major issue affecting Nevadans, but there's many legislators who themselves are frustrated trying to pass legislation. And with Dillon's rule, it's so confusing whether it goes to state, whether it goes to city, where it's a county issue. So I really strongly urge the members of the committee to pass SB 371. Thank you so much.
Thank you. Next caller.
Hi, yes, my name is Dion Klug, DIONNEKLUG. I am with the United Food and Commercial Workers Union, Local 711 out of Las Vegas, and we strongly urge you to support this bill. Thank you.
Callers, if you would like to testify in support of SB 371, please press star 9 now to take your place in the queue. Chair, there are no more callers choosing to provide support testimony at this time.
Thank you. At this time, we will go ahead and move into opposition. And I believe that we do have an individual that's going to kind of do a presentation, a short presentation for opposition, Mr. Azim Jessa. So we will go ahead and start in Las Vegas, and you will begin. I'll go ahead and set a timer for up to 15 minutes, although I don't expect that it'll take that long. Thank you.
I'm not nearly as educated as your legislative gentleman there. I cannot speak that long about these topics. So, Madam Chair, members of the committee, my name is Azim Jessa, and I'm here as the Vice Chair of the Nevada Realtors Legislative Committee and a realtor with Urban Nest Realty here in Las Vegas. The Nevada Realtors are here in opposition to SB 371. SB 371 would grant home rule only for affordable housing and rent control. Because there are numerous local jurisdictions in our state, this would create varying rules on affordable housing and rent control for each county and municipality. For example, the cities of North Las Vegas, Henderson, and Las Vegas would all have different affordable housing policies than the counties they reside in, making it extremely difficult for residents, property owners, state agencies to navigate the housing market. The realtors consider rent control to be a flawed housing policy that diminishes housing values, discourages production of new rental units, and can lead to a reduction of available rental units. Rent control negatively affects the housing inventory by accelerating deterioration and a loss of existing housing. The expense of complying with rent control regulations, especially if they vary in each local jurisdiction, inevitably increases the cost of housing to the consumer, and the expenses of enforcing rent controls adds additional burdens to local governments and regulatory agencies. The solution to high rent is increased supply. Our state is an attractive place to live. Between relocation and retirement of those from other states, as well as many Gen Zers now being financially ready to move out on their own, Nevada is short inventory in both rental and resale homes. Many who can't find a home to purchase are renting, putting further strain on the already limited rental inventory. Rent control does nothing to lower the high rents that we all agree are higher than many folks can and should have to afford. All it does is protect the current occupant, but then harms all subsequent renters with higher adjusted rents, rundown homes, or a loss of a unit to the resale market due to a lack of revenue to properly maintain that home. We encourage this committee and legislative body to continue to work with us and other stakeholders to find real solutions to Nevada's housing affordability issues. Countless economists from both the left and right side of the aisle all agree rent control is a poor solution for affordable housing. The Nevada Realtors strongly urge you to vote no on this bill. Thank you.
Madam Chair, if I might, this is Keith Lynham. I'm the chairman of the Legislative Committee and a realtor in Southern Nevada.
Go ahead. And then I know we have a couple questions, but I'll let both of you do your presentation first. Thank you.
Just real quickly, I'd like to bring us back to this, as you know, this gives the local municipalities the ability to change those and affect those changes in as an example, rent control. We don't know what that's going to end up looking like. It could be far worse than it is now. This is about affordable housing. This is only about affordable housing. We all agree things have gotten out of hand, and we need to get more homes on the market. We need Nevadans buying from Nevadans. That's what we need more than anything. And I just want to point out that we have tried this already, and it has failed spectacularly, in that we have allowed local municipalities to set their own laws and regulations for things like vacation rental. Now, this isn't about vacation rental, whether it's a right thing or wrong thing. It's allowing those municipalities to set those rules. I don't know what the rules are in North Las Vegas when they compare to Henderson, when they compare to Las Vegas, when they compare to Clark County. And neither do the investors that come in and want to have that as a service. It is a crazy, confusing market when it comes to that. We can't allow that when something so vital as renting to our Nevada workers. And so that we will take any questions you might have.
Thank you. Members, any questions? Assemblywoman Gonzalez.
Thank you. Thank you so much, Chair, and thank you so much for your remarks. I just had a quick question. In your remarks, the first person who spoke, I apologize, discussed that enacting this policy would allow different jurisdictions to have different rent controls here and there. And without this, that's currently what's happening. And so I was just kind of confused by that point argument, and I was curious if you could expand upon that more. Thank you.
Thank you for your question. This is Azim Jessa for the record again. So as Keith explained, right, the example he gave was a really good one with short-term rentals, with having different rules in each market. That makes it difficult, right, for anyone who's working in those spaces to really fully understand what the rules are specific to each area. The same thing would happen with rent control. So if North Las Vegas, let's say, just picking a city, enacted, we're going to have a X% cap, right? And then someone across the road, I believe, Chairwoman Torres said she lives across the road. If someone in her neighborhood rented a place and they may have Y% cap and it would be plus CPI, not CPI, there'd be so many varying things that it would be difficult for property managers who maybe manage those properties to really fully know every single rule. And we want to make sure that we're treating everybody fairly and not getting into trouble. We want to make, we all want the same goal, right? We want affordable housing for everyone, and just adding extra time and effort and regulatory issues, it's going to increase the cost of housing everywhere. And that's our concern with having rent control at a, individual jurisdictional level.
Yeah, follow up. Thank you so much for your response. I'm just confused. So what you're saying is that because it would be more work for people in different jurisdictions to do this, that's why you're in opposition?
Keith Lynham, Chairman of the Legislative Committee. It's not the work, it's the confusion. And it's not just confusion for those property managers or those landlords, but it's also for the consumer as well. One side of the Sahara and the other side of Sahara will be under two different rules, two different regulations. And so it's the consumer that's going to be as confused as anybody else, just as they are now with the vacation rental. Again, this is about affordable housing. And as you know, we have supported many bills that get us to that affordable housing. We have worked with all of these bills, but we are working towards getting an affordable housing. That's what this amounts to, is getting more homes on the market that are for lease and for sale.
And if I may add on to that, Azim Jessa again for the record. Yeah, I mean, more work does increase costs, right? If you or I hired an attorney, if we're going to ask them to do additional things, they're going to charge us more. It's going to be the same thing with anyone that manages property, right? If they have to look up various regulations and report to different agencies multiple times, then of course there are going to be increased costs, and therefore there's going to be higher pass through to the consumer, which again we don't want. We want lower homes, lower home prices, lower rent prices, and that's our ultimate goal along with you guys.
Members, any additional questions? Assemblyman De Silva and then Assemblyman Thomas.
Thank you, Madam Chair, and again, thank you again for your presentation down there in Las Vegas. So I have a two-part question. Okay, so one, if there was to be enacted some sort of rent stabilization measures, so you're saying that it would be better to have a statewide sort of approach where everything would be kind of understood, regardless of the locality or the local county. And then secondly, so is this the same in regards to affordable housing? Should it be a statewide approach to the issue of affordable housing, or should it be something that should be really adjudicated and planned out at the local level?
Keith Lynham, Chairman of the Legislative Committee for the Nevada Realtors. Yes and yes, Mr. Assemblyman. That's the short answer. A statewide effort to increase affordable housing is absolutely needed. And that's what we're working forward to. I don't want the point to be lost that we work for both sides of this argument. We are unique in that regard. No one else can make that claim. We represent landowners and homeowners, and we represent the tenants that lease from them. We represent both sides of this, so we want what's best for both sides. And I can tell you that more regulations for rent control is not the answer. What is the answer is an effort to increase affordable housing. Let's get behind that with programs that can work and that can be effective in getting Nevadans to buy homes from Nevadans and Nevadans to lease homes from Nevadans.
Just a quick follow-up. So something like a statewide, inclusionary zoning, or some kind of an approach to creating grant monies maybe for affordable housing projects. Is that something that would be workable here in this regard? Thank you.
For the record, Keith Lynham with the Nevada Realtors. Yes, without getting specifics on them, but absolutely. I mean, I think all those things need to be discussed, need to be put on the table, and have some sort of a discussion on what we can do statewide to increase affordable housing. So absolutely. We'd be behind you 100%.
Thank you. And I'll remind the body, too, that we actually have a couple of those bills. I think at least one of those, Assemblywoman Monroe Moreno presented one of those bills in this committee regarding creating an account specifically for affordable housing. Assemblywoman Thomas.
Thank you, Madam Chair. My question actually has to do with the local government aspect of this. So what we are hearing right now for rent initiatives, since everyone is getting upset about control, the rent initiative that I see that this bill would allow for local government to enact, I'm not understanding the pushback on it, because now you're saying to me, if I heard correctly just a moment ago, that the state should dictate to the counties and cities what should happen with its constituents, and that the better people that know what happens in their local jurisdiction should not count. The state should make the formal rent initiatives and or affordable homes and or whatever you want to, for vacation homes. So the state should be the one, overreaching local government. That's what you're telling me right now. Is that correct?
Assemblywoman Thomas, thank you for the question. Azim Jessa for the record. Well, so we would prefer the system to remain as it is and work with the local stakeholders to find solutions to affordable housing. We've heard people speak earlier today about how Senator Flores said that each individual county and area has different needs, and we truly believe that as well, right? That Nye County is different than Clark County, that's different than Washoe, that's different than Elko, and we want to make sure that each individual community can work in a manner to get what they want done without having like state overreach as well, right? So our arguments are against rent control. That's at the end of the day, that's what this issue is about. It's a misallocation of resources, right? We've talked about this before, that folks are trapped in their homes. They don't move because they have a controlled rent. And then when other folks move into the area or need that same piece of property, they're not able to move into that rental unit because it's locked up by someone who has rent control, right? And if you give landlords a target to increase by every year, they're likely going to shoot for that. We've seen that in other markets. If you say you can increase, I'm just going to make up a number here, 5% or 10% a year, they're going to hit that number. And we truly believe that the free market will allow rents to come down. And the best way for that to happen is to increase supply. Like, we need increased supply. We need to work at the state level and the local level to find ways to get affordable housing. And affordable housing is more options available for people.
Madam Chair, if I might, Keith Lynham.
Yes, go ahead.
Chairman of the Legislature. Let me be clear. If there's any confusion, let me be clear. We're not in favor of a rent control initiative locally, statewide, federally, or any other way. And the reasons are clear. Left and right, think tanks across the board have proven it doesn't work. What does work is statewide initiatives to increase affordable housing. That's what we're in favor of. We're not in favor of restricting Nevadan homeowners from being able to lease their properties out to Nevadans. We are in favor of increasing the affordability and availability of homes in this state. And so we want to be very clear about that. And hopefully we are.
Thank you. Assemblyman Carter.
Thank you. So I've heard repeatedly Nevadans for Nevadans and about Nevadans should be renting from Nevadans. So would you all support some type of an effort to disincentivize out-of-state landlords and big investment groups buying up our stock of single-family housing, such as maybe doubling property taxes for out-of-state owners of single-family residences or something like that?
Azim Jessa for the record. We would love to have some sort of, carrot approach to maybe take some inventory out of the hands of out-of-state investors and put it back into the hands of Nevada homeowners. We would 100% be behind that movement. Again, we can discuss specifics at another time, but in general, yes, we want to see more homes available on the market so that folks who want to buy can get out of the rental market and into homes, and then that frees up inventory for folks who need to rent or want to rent instead of purchasing. We're 100% in support of that.
Members, any additional questions? Vice Chair Duran.
Hi, thank you. My question is, you just basically said that landlords would increase the rent every month. They're doing it now, aren't they? They have can do it every year if they like to, every 6 months if they would like. Is that not true?
Keith Lanham, Nevada Realtors. When you talk to what I call mom and pop investors, no, they're not. In some cases, we've got clients that have been leasing to the same person for over a decade. and haven't raised their rents. What you're going to be forced to do, though, is when you start to limit, especially these out-of-state homeowners, the Wall Street hedge funds, you're going to incentivize them to annually increase every year, whether they wanted to or not, and most of them do, but the Nevada homeowners don't. But you're going to increase them every year because that's how they're going to stay ahead of the curve. And it's proven out. It's not just us saying it. It's happening in other markets already.
Thank you. So I do have another question. So would you provide your expertise to city council members and commissioners if they were looking to affordable housing measures? And would you presently work with, and do you presently work with the city and county on these issues that impact realtors?
Azim Jessa, for the record, thank you for the question again. And yes, we do work with local and city governments here. You know, I live in Southern Nevada, and I can speak to the area down here. We do have we do have the conversations. We do have our hand in the conversations and trying to do that. I know we need help at the state level and even federal level regarding release of land, for example, BLM land and stuff. But we certainly want to come up with any fair solution that would increase inventory and lower rent prices.
Thank you. Assemblyman De Silva, I believe you had an additional question.
Thank you, Madam Chair. And again, I have a question, and this kind of is in vein with many different conversations that were taking place here, including Assemblyman DeLong and Gurr, and that is the term rent control. My question would be this: would you be more inclined to support this bill if the word rent control was removed or replaced with another term? Thank you.
I don't think the term is what we're concerned about. It's the confusion that it would create. You can call it whatever you want, but it's the confusion. It's the guaranteeing of the rates increasing, but more than anything, it's the confusion for the tenants and it's confusion for the homeowners. It really does. The term is irrelevant to us. It's the impact that it'll have on the markets. And we have actually made some efforts to incentivize Nevada homeowners to sell to Nevadans. That's the best way. You want to eliminate you want rent control. Tenants being able to buy their own homes. That's the ultimate in rent control. We should be encouraging that to be able to put tenants into their own homes with the pride of home ownership.
Thank you. Members, any additional questions? Assemblywoman Thomas.
Thank you, Madam Chair. Again, I'm not understanding. I think this, if the bill sponsor said that this bill is not about, it's about giving local government the autonomy of governing. And now I'm hearing it's about rent control, it's about, looking at, affordable housing and vacation homes and et cetera, et cetera, et cetera. Again, I think I raised the question earlier, is this, state overreaching, or are we allowing local government to govern as we elect them?
Azim Jessa, for the record, the conversation in our belief, and I think in many of the people that have spoken today, the concern is rent control, right? That at the end of the day, that's why this bill is being brought forward, right? They want to give local governments the ability to have rent control. And we believe that rent control is a flawed policy and will do significantly more harm than good.
Thank you. Members, any additional questions? And I did have one last question. So based off the conversation that we had, and I understand the concerns with the term rent control, would you all be comfortable if it just talked about like measures relating to affordable housing?
Azim Jessa, for the record, yes, and we're already working with folks at the local level and at the state level for affordable housing, as Assemblyman Gurr said, like if we want to have real solutions, let's have some real conversations and dig down in this. You know, you can contact us through various channels. Keith and myself will be there next week. We'd love to have sit-down conversations with you. Anybody who wants to talk about real solutions to affordable housing. It is extremely important to us and our membership as well. I've spoken with various people on various sides who understand that in the short-term rent control will help people in the immediate housing situation, but in the long term, it's always a bad thing. But unfortunately, right, that message isn't always clear, and we're ready to have that conversation and really work on affordable housing at the state level and the local level.
Thank you. I appreciate it. And thank you for coming and taking all of our questions today. It's clear there was coffee downstairs, so it's clear that my members were able to grab a cup before coming into committee this morning. So thank you so much for your testimony. I'm going to go ahead and come back to Las Vegas, and we're going to go ahead and hear those wishing to testify in opposition to SB. I apologize, in Carson City. Forget where I am sometimes. I'm going to come back to Carson City, and I'll take the opposition for SB 371, just like we did previously. I will allow up to 20 minutes in opposition testimony. If somebody before you says something, and I know we obviously just had the presentation, feel free to just say ditto or I agree with my colleagues, so we can continue to keep the hearing moving. But back here in Carson City, when you're ready.
Chair Torres, thank you. For the record, John Sandy here today on behalf of the Nevada State Apartment Association. It's been a fascinating conversation, and there are some legal nuances there that I think is being lost. And the reason why we say this is a rent control bill is because the bill starts by saying it's addressing affordable housing. But there's a lot of different measures that fall under affordable housing. In fact, it's a lot of the local governments are already addressing affordable housing, and so obviously have the ability to adopt affordable housing ordinances. For example, City of Henderson has home ownership programs, first-time buyer home programs. City of Reno has the Rural Reno Housing Authority, which is there to help provide fair, sustainable, quality housing for low-income families to pursue economic opportunities. North Las Vegas, has housing and neighborhood services division that offers a variety of programs which are designed to enhance affordable housing and promote public services throughout North Las Vegas. The issue that we have with the bill is that it specifically calls out rent control as something that local governments can pass. And so that's our opposition. I think the realtors did a good job. Give a little perspective, and 32 states have actually passed bills the opposite, that have said local governments cannot pass their own rent control. Only 8 states permit local governments to implement rent control, and it should come as no surprise that many of those states are have some of the highest rents in the nation. I'd like to turn to some of the reasons rent control is not a solution to our housing crisis. Many researchers have observed the negative impacts of rent control in jurisdictions that have implemented these policies. These impacts include reduction in investment and development, disincentivizing investment in maintenance and improvements, and encouraging owners to convert rental units to condos. If any one of these impacts are realized in one local government and not the others surrounding it by an arbitrary invisible line, those could have serious ramifications for both local governments. And I'd like to conclude with a quote from an article from Walter Black reviewing the economic research on rent control. Mr. Black stated, "The agreement that rent control is bad cuts across unusual political
Thank you, Mr. Senate. If you could please wrap up. Thank you.
If I might say, Nobel Prize winners Milton Friedman on the right and Swedish Labour Party's welfare Nobel laureate Gunnar Myrdal on the left have said that essentially, in many cases, rent control appears to be the most efficient technique presently known to destroy a city, except for a bombing. It's not a good policy, and that's why we're opposed to it today. Thank you.
Thank you, Mr. Senate. Please make sure you submit your written remarks to our committee staff as well. Thank you.
Good morning, Jennifer Lazovich here today on behalf of PSERN. PSERN is the owner, developer, and operator of several multifamily projects down in Southern Nevada. We are here in opposition to this bill, predominantly because of the words or the use of the words rent control. Separate from this, I, in my other capacity when I'm not up here in front of all of you, I work with all of the local governments down in Southern Nevada on land use related issues, and I have handled multiple items or projects, I should say, for affordable housing, both for affordable housing for seniors, and I've had some attempts at some affordable housing for families. They're met with a lot of opposition, no matter where the neighborhood is that you try to go. But I've been proud to stand on the side of trying to bring those projects into all parts of Southern Nevada, and I'll continue to work to do so. My opposition is not to the fact that we need affordable housing down in Southern Nevada. It's just that we would like to do it in a way that doesn't involve rent control. Thank you.
Good morning, Madam Chair. Brian Wachter, Senior Vice President of the Retail Association of Nevada. We are opposed to Senate Bill 371. In fact, we'd like to thank the sponsor for his vote in 2015 on AB 493 because that was a bad idea at the time as well. We have a slightly different take, certainly not being in the landlord-tenant business when it comes to housing, but we are the industry, and it's through our members and the taxes on our members that largely fund both state government as well as local government here in Nevada. And so we are greatly frustrated as well as concerned about enhancing the different activities as well as the authority that our local governments have. You know, we talk about the nature of those who are unhoused, and it's a very transient population, especially when you look in Clark County. And so the idea that you can both have different jurisdictions have slightly or completely different policies in regards to, in this particular case, housing affordability, and at the same time still have an operable and congruent system in which businesses and consumers can interact without having to worry about whether or not they've stepped east or west of Decatur or north or south of Sahara. And so for all of those reasons, we think it is inappropriate that local governments would be able to kind of execute at this particular level. We also feel that you as the legislature are the most appropriate body to be addressing these very large and complex issues that affect the entire state. You spend a considerable more time on these pieces of legislation than you could ever do in an evening hearing at a local government jurisdiction, and you do so with a research, fiscal, and legal research arms that allow you to be able to make decisions at the best and highest possible level, and that's where we feel this belongs. Thank you.
Thank you. And it sounds like Mr. Wachter is proposing to work on a rent control bill next session. At this time, I'm going to go ahead and go to the phones. I don't believe there's anybody else in Las Vegas wishing to testify in opposition to SB 371, but we'll go ahead and go to the phones and take 3 callers.
Callers, if you would like to testify in opposition to SB 371, please press star 9 now to take your place in the queue. One moment, Chair. Caller with the last 3 digits, 951. You're unmuted on our end. Please go ahead.
Good afternoon. Thank you, Madam Chair and members of the committee. My name is Emily Osterberg, and I'm here on behalf of the Henderson Chamber and our more than 1,800 members, most of which are small businesses. Home rule for affordable housing and rent control gives unnecessary power to local governments while limiting the oversight from the state. For these reasons and the previous comments of those testifying, the Henderson Chamber opposes SB 371. Thank you.
Chair, there are no more callers choosing to provide opposition testimony at this time.
Thank you. We'll come back to Las Vegas, or back to Carson City.
Good morning, Chair, members of the committee. Paul Moratkin with the Vegas Chamber. The Chamber is opposed to SB 371. I do want to just delineate some of the policy conversation today from the Chamber perspectives that this is regarding Dillon's role versus fiscal rule and rent control. There are 2 components in this conversation from the Chamber perspective. And as you've heard in the comments today, Nevada has been a Dillon rule state. It was codified in 2015 where this body did relax some of those guidelines based of AB 493 the Chamber was heavily involved with. And our view is that Nevada is now a Dillon rule state that allows local government functional home rule, but the fiscal oversight remains in this body, and that's a position that we encourage this body to continue that is long held in both chambers and over many legislative sessions. And the reason is that fiscal home rule is what we have seen in California, where I think many of us would argue that California's fiscal policies have not worked overall and throughout their state, constantly in budget deficits and local government crisis with their management and so forth, and no one would argue that California has affordable housing prices. So because of that reason, the Chamber believes that we should preserve our role here as a dual enroll state. And then obviously, as you heard from the industry, there are challenges and failures within the rent control sector, different policies throughout the country. So for those two policy reasons, the Chamber of Commerce is opposed to SB 371. Thank you very much.
Good morning, Chair and members of the committee. Lindsay Knox with McDonald-Crono, here representing the Nevada Builders Association, the Southern Nevada Builders Association, and the Builders Association of Northern Nevada. Our opposition to this bill is largely based on uncertainty. The lack of defined terms for affordable housing is concerning. The lack of a defined term for rent control, the fact that it is non-exhaustive list of things that can be done in the name of affordable housing is also concerning. Some other items might include fees, inclusionary zoning, and these are very complicated areas, and it is very important to get them right so that they do not have negative impacts on trying to bring supply to the state. With respect to this bill, the concern is the uncertainty and will lead to confusion and misunderstandings. The lack of specificity is why we are here in opposition today. Thank you.
Good morning, Madam Chair. Committee, for the record, Susan Fisher with McDonald-Crono, speaking today on behalf of Ovation Development. Ovation Development is a legacy developer in Southern Nevada that has developed thousands and thousands of affordable housing units. And I would like to point out that on the front page of the Las Vegas Review-Journal this morning, there was an extensive article about rents decreasing in Clark County. So we are here in opposition to SB 371 for all the reasons that have been stated already this morning. Thank you.
Thank you. Go ahead.
Thank you. Good morning, Chair Torres and members of the committee. My name is Chase Whittemore with our Argentum partners here today representing Nevada Builders Alliance. Affordable housing is a very extremely complex topic, but what isn't complicated is that there's likely been no other economic issue that's been studied by economists more than rent control. And the data is crystal clear. Rent control is a terrible idea. It leads to less supply, it leads to labor immobilization, it leads to less reinvestment in rental properties. If we want to lower rental prices and the cost of living, we need more supply. Inclusionary zoning and higher density. More supply will lead to lower rental costs. Another big issue is the time to development. Time is money. Lower the upfront development costs. Improve local government processes and procedures to increase the speed at which new development can occur. Those are the ways to tackle this issue, not an arcane idea that's been fundamentally disproven by economists around the world. Thank you.
Thank you. And I don't see anybody else in Las Vegas wishing to testify in opposition to SB 434. BPS, is there anyone on the line wishing to testify in opposition to SB 434?
Chair, the line is open and working, but there are no callers choosing to provide testimony at this time.
Thank you. Is there anyone wishing to testify in neutral to SB 434? I do not see any here in Carson City. I don't see any in Las Vegas. BPS, is there anyone on the line?
Chair, there are no callers choosing to provide neutral testimony at this time.
Thank you. At this time, I'll invite the bill sponsor for any closing remarks.
Thank you, Madam Chair. Senator Edgar Flores for the record. I wanted to honestly start off by thanking the opposition. I know they're very involved in the community. They represent very unique lenses. And this is a subject matter that they're obviously experts in. They represent a specific lens, but I think they are honestly experts in that respective lens, and I do respect them. In fact, some of my best friends, particularly one of them, who's very prominent in Southern Nevada, he's a realtor. I asked him about rent control previously, and he alluded and echoed some of the remarks that were made by some of the realtors, saying if you put a cap at 3% or 5% increase every year, you may see that some of the landlords will inadvertently start using it because they'll be concerned that potentially down the road they won't be able to increase it if they have to. They also brought up concerns about 3 to 5% is kind of what the market dictates now. It's kind of a common practice. That's usually what some of these renters can expect. Their rent will increase yearly. He also talked about on some higher end properties, you can see an increase from 7 to 10% or 5 to 7%. There was a very long-winded conversation to make it abundantly clear that absolutely it's complex. And to make it abundantly clear that it may inadvertently backfire, right, for folk that support rent control, that it might go in the opposite direction because all of a sudden all landlords are going to start increasing their rent by 2 to 3%, et cetera, et cetera. I make that point only to make clear that I agree with you. Rent control is incredibly complex, and it might not be the right solution. But I also want to make this point. There was 3 main concerns raised today. And one concern is some folk are against this bill because they simply disagree with home rule. They opposed it in 2015, they opposed it in 2019, and they're consistently opposing it now. And to them, while I agree with them, I've never been a big fan of home rule. I just want to say, unfortunately, we lost in 2015. That's what this body did, and that's what the law is. We lost. So to them, I can't provide a solution to their concern. I get it, because I've had it since 2015, but that boat has sailed. We lost that fight in 2015. That's the law in Nevada. We have modified Dillon's rule. For the folk who brought up the concern about affordable housing, that this bill is wrong because affordable housing is very complex. To them, I remind them that absolutely is very complex. And that's why if any local jurisdiction tries to enact something now, because they are already authorized, I am only clarifying what they already can do, that they're going to do exactly what they're doing now. They're going to go and lobby them. They're going and sit down and provide their expertise. In fact, our realtors specifically made it abundantly clear that obviously they care about this and that this is something they do already. They sit down and speak with local jurisdictions already because, of course, this impacts their membership, and they care about this, and they're passionate about it, and they want to make sure that their membership is adequately represented. What they're doing now is what they're going to continue to do. They're going to continue to lobby council members. They're going to continue to lobby commissioners. They're going to continue to press their issues. They're going to provide their expertise. They're going to provide testimony. They're going to go to an open forum and do all that. They're going to continue, and nobody in this room, not you, not the folk behind me, not the experts that testified in opposition, will be left out of that conversation. They're going to be very involved in their local jurisdiction. But what you're probably not going to see is somebody maybe from Nye County coming into Clark County saying, well, you're trying to do this in Clark. You probably won't see that. And that makes sense because that's kind of the point. That's why this whole thing happened in 2015 to begin with, because we wanted local jurisdictions to enact whatever they felt were matters of local concern, and we gave them that authority. We will see interlocal agreements should certain things happen. Of course we will. That's the point, because we're going to force it. The experts in the room are going to force that to occur. We want to make sure that there isn't something happening in location A but not location B if it's just the only thing that separates them is a street. All those conversations that are incredibly complex are going to be vetted. And they're not going to be vetted in 120 days out of desperation. We're frantically trying to figure out everything for the state. They're going to do it for many, many, many months. Many, many, many months in a very concentrated area, in a very focused manner, in a way that none of us here can do. None of us here can address this very complex crisis in 120 days. They're going to be able to engage in that in a very focused manner for several months, and it might take them a year and a half. And there's going to be some local jurisdictions that aren't going to do it at all because they don't need it. What this bill is saying is those of you who desperately need to do something about affordable housing. Now, I also wanted to make it abundantly clear, which is the third concern and probably the more important one, which is how this bill reads. And I like that it's a single page because I just fold it up and put it in my pocket. That's how simple this bill is. And I think there's no more famous words, but I just wanted to say this. Madam Chair, this is all I wanted to say, and then we end it there. Except as expressly prohibited by statute, a board of county commissioners may enact any ordinance or measure relating to affordable housing. I added the language including without limitation, rent control, because I wanted those conversations to occur. And again, I wanted to put the special emphasis on it. But if we remove without limitation rent control, and the bill just reads, may enact any ordinance or measure relating to affordable housing. And our realtors have said that they would agree with that bill. Mr. DeLong said he would agree with that bill. I am willing to work with you and make that happen. I put specific terminology to force a conversation, and I appreciate us having it, but I 100% agree with you that there's a million things that fall under affordable housing, and all of them should be considered. But I absolutely needed to have this conversation, because had I just started with the bill that said affordable housing, there would have been a whole host of folk that said, I won't do it. But I forced the conversation to rent control because I knew that we would be a compromise, and here's the
Senator
compromise.
Flores, if you could begin to wrap up.
Madam Chair, I think the compromise and the handshake with everybody, both our realtors, with myself and Mr. DeLong, is I've removed those words. We shake hands. We got bipartisan love, and I appreciate all of you for agreeing with me, and I appreciate the opposition's work. Thank you.
I think this committee is going to have a new rule. It's going to be called the Senator Flores rule, and it's going to be closing remarks have to be limited to 2 minutes or less. Thank you, Senator. At this time, I'll go ahead and close the hearing on SB 371, and we will move on to the next item on our agenda, which is public comment. Is there anyone here in Carson City wishing to testify in public comment? I don't see anybody approaching the table for public comment. Is there anyone in Las Vegas wishing to testify in public comment? BPS, is there anyone on the line wishing to testify in public comment?
Chair, the line is open and working, but there are no callers choosing to provide public comment at this time.
Thank you. At this time, members, are there any remarks before we close? If Senator Flores was here, I'm sure he'd have many of them. It doesn't appear that there are any additional remarks at this time. As a reminder to committee members, we will be meeting tomorrow, and we will be meeting at 10 a.m. I will note that we have updated the agenda due to the bill that dropped yesterday, so we will be hearing AB 514, and we will have a work session on 6 bills. I believe that agenda has already been posted. We will also have our very exciting committee party tomorrow evening, so make sure you all are ready. I have something special being delivered to your offices today in preparation for that party. Thank you. At this time, the meeting is adjourned.